Mr. Ortiz, I understand you're representing yourself?
Yes, Your Honor.
Okay, absolutely.
morning,
You
Your
understand you
Honors.
have 20 minutes, and you have the opportunity to have rebuttal time. Just let us know.
Yes, Your Honor. I would like to reserve 5 minutes for rebuttal.
Okay?
Your Honor, first, may I please the court, and may I proceed?
You may.
Your Honor, we're here today on summarial dismissal on a habeas corpus petition out of the Shelby County Criminal Court. The case arises and raises a number of issues. I will not be able to get to all of those issues today, but I believe that I would like to focus on what I consider the four main pillars of my arguments, which one is the indictment from the original case in 2008, the subsequent and the errors found therein that my position that voids the judgment, which is the standard for habeas corpus as I understand it from my reading of the case law and the law itself. The jurisdiction over the person for the issue of a capias by a court that lacked jurisdiction at the time in 2008. The failing of the charging instrument indictment and including the provisions or provide notice of the state's intent to charge 3913-524 as part of that indictment. The indictment was a single count indictment arising from TCA 3913-504, which is aggravated sexual battery. And that indictment is, as I said, a single count indictment. They indict 504, yet the judgment sheet and the follow-on orders from the court imposed the provisions, the mandatory provisions of community supervision for life under Tennessee Code annotated 3913-524. But the state had failed to include those, and under the rules of criminal procedure, I believe it's Tennessee Rules of Criminal Procedure 8, it requires that any offenses that arises from the same conduct be joined on the indictment, and that requirement is mandatory. Under Apprendi, we also find that any fact which increases the sentence on a criminal defendant beyond that which is prescribed for the common law felony requires that and this is from the United States Supreme Court, Apprendi v. New Jersey, where they held that any fact that increases the any fact that increases the penalty that a criminal defendant is exposed to must be indicted and presented to a jury and proven beyond a reasonable doubt. That did not happen in this case. And then finally, I will close with my remarks on the recusal arguments, which was granted by this court through a motion, through discourse orders to brief the recusal issue based on some of the language that is found in that order. So turning to the original indictment, in 2008, Mr. Ortiz, and I'll make all of my arguments in third person just for flow and to be able to make that a little easier for myself. In 2008, Mr. Ortiz was indicted, like I said, on a single count under Tennessee Code 3913-504. That criminal offense is found under the criminal code of this state. And in that criminal code, what we see is that there is no reference on 504 to the requirements of 524, which is found some 20 subsections later, which indicate that any person that is found guilty of 504 must also mandatorily be sentenced to this lifetime supervision. So it takes what would have been, in this case, a 3-year sentence and converts it into a lifetime sentence for that criminal defendant. However, that fact was never disclosed to the defendant in this case through that indictment as required under Apprendi. And because 524 is a separate offense, Tennessee law under Tennessee 43102 requires that all offenses or all violations of the criminal law be indicted. The judge's position in his order summarily dismissing the petition for habeas corpus stated that that the practice for the indictment, that because the requirements of 524 were mandatory, that therefore, and I think the state follows this kind of vein of thought, that therefore, because it was mandatory, not having it in the judgment sheet would make the judgment an illegal sentence. But this court has to balance both the protections of the defendant and the interests of the state. And what do I mean by that? Well, the state wants to be able to impose this higher sentence. They need to be able to provide notice, or they are obligated to provide notice to the defendant and give them the opportunity to develop a strategy and a defense for those offenses. When the indictment omitted 524, it deprived the criminal defendant of that ability. The second jurisdictional issue that we find on this case is that same 2008 indictment, on the face of that record, it shows that the grand jury identified a Shelby County sheriff as the prosecutor for that indictment. And Tennessee Code 233102 prohibits sheriffs in general from practicing law, and the practice of law is defined by statute under that same provision. I think it's 101. It has the definitions for that, and in that definition, it goes on to say that anything that is even pending before the courts or is anticipated to be before those courts in the counties where the sheriff serves, the sheriff cannot practice law in those counties. It is our argument that when the sheriff, as it is found in the indictment and endorsed by the grand jury and the foreman from the grand jury, indicated that this person who did not have the statutory authority to prosecute that indictment secured the indictment and then returned that indictment to the General Sessions Court. And the General Sessions Court, as this court is well aware, once an indictment is returned from the grand jury, it loses subject matter jurisdiction over anything left in that case, and that plenary jurisdiction is transferred to the criminal court. In this case, the General Sessions Court, despite that prohibition, issued capias and set bond after the indictment was already issued. And I think that voids the jurisdiction over the person, because if there was no valid capias, there is no valid arrest. If there's no valid arrest, there is a violation of constitutional rights. Moving to the charging instrument, I think I've talked about this already, but under Apprendi v. New Jersey, the U.S. Supreme Court has taught us that whenever a fact increases that sentence, it must be indicted. We believe, and it's our position, that because 524 was never indicted in the original instrument, there was not sufficient disclosure to the defendant of what the ultimate sentence would be in this case, and therefore deprived them of the proper notice. It is my understanding from the reply that the state filed, the response that the state filed, is that they seem to also carry this idea from the trial or from the habeas court, in which they say, well, that's irrelevant, It doesn't void the judgment. I think that the case law disagrees. I think that in our reply, in the reply brief, we touch upon the limits of Hill, State v. Hill, where the Supreme Court has stated that any indictment that is missing an essential element, and that's how I take the state's argument, is that they argue this was an essential aspect of this crime, and therefore it must be indicted. Hill tells us that any indictment that is missing an essential element to the crime also is void. So I feel like there is this predicament that we find ourselves in, is that if it's not in the indictment, it seems that the indictment is void based on the readings of Apprendi, Ussery, Archer, Anglin, and others, and Hill. And if an essential element is not included initially in the indictment, it's also a void indictment based on Tennessee precedent. Moving to the recusal issue, Your Honor. So this case originated in September 6, 2024. The petition was filed with the clerk of the criminal court, and based on my reading of the statute, the court, it is the duty. There is a duty imposed by the legislature upon the court and the judge who receives these applications to act upon them instanter is the word that the statute uses. I take that to mean immediately. Now, what immediate means based on circumstances may change. This court is the one that has to reach that decision, what that word's interpretation is, because there is no definition of what that is in the statute. But the plain meaning of it means that it's immediately. Because of the serious constitutional rights being protected under habeas corpus, when a judge takes a petition for habeas corpus and converts it into a post-conviction petition without an opportunity for amendment and without the opportunity for appointment of counsel and other protections that are available, then it deprives the defendant or the petitioner of his due process rights under the habeas corpus statute. Further, the habeas court judge went on to make findings of fact and credibility findings on the petitioner, with whom he never had a hearing, never had a conversation, never cross-examined them, never asked questions, but somehow reached a determination that the petitioner was being deliberately distruthful. This is in the court's orders at volume 1 of the record, around page 91 through 125. And it's replete of repeated instances of the court calling the petitioner a liar, deliberately distruthful, and that the claims that were being raised were meritless. But in the same vein, admits to all of the things that are being said, were being alleged in the petition, and I cannot square that round hole with that square peg, because either I am lying and the record does not support what the allegations are, or or the record does support it, and based on the court's own order, the record that hopefully you guys will get, your honors will get an opportunity to review, you will find that the record shows, and it's replete with every claim that the petitioner has raised, and it shows that the sheriff was the person who prosecuted the indictment, was the person who also acted as a witness in the grand jury proceedings, secured that indictment, and then went on to continue to do other things that are part of the record. And if the allegations are true and they are supported by the record, I really think that it goes to the impartiality of the judge to to make credibility findings without holding a hearing or questioning the petitioner or having some sort of intervention where he can make those credibility findings and reach those assessments. Finally, Your Honor, I would say that it's mind-boggling to me to see how pro se petitioners are generally treated. If we are coming to the court and the court gives us the opportunity to seek redress, they should be treated with respect, not dismissive and just tossed aside. This case, well, like I said, started in September 6th. It languished for 214 days, where the statute requires an immediate action. I'm not sure that 214 days of no action and then an order following a mandamus case in Chancery Court seeking some action in the petition was appropriate. So we ask this court to reverse and remand with instructions for a new hearing or for some adjudication of this case on the merits, Your Honor.
All right, thank you, Mr. Ortiz.
Thank you, Your Honor.
And you still have 5 minutes rebuttal if you choose to use it. Mr. Coleman.
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the summary dismissal of habeas relief because the petitioner failed to state a colorable claim. And first, I'll say I appreciate this coming for oral argument. Mr. Ortiz, I think, was incredibly eloquent and laid out the 4 arguments that he's presented today, and I will address them sort of in turn as they were presented, or maybe in a little bit of order, as they were presented in the briefs. So first, and I think it's important here to take a second to recognize the procedural vehicle that we're here under. A petition for writ of habeas corpus in the state of Tennessee, this court and our Supreme Court has described as incredibly broad. And the only 2 bases that you can get habeas relief for is if you show that the trial court lacked jurisdiction to impose the judgment or that your sentence has expired. And neither of those are here today. So first, the petitioner attacks his indictments in a couple of ways. The first way he does is by arguing that it listed the sheriff as the prosecutor and that the sheriff was acting in violation of the law, representing himself out to be an attorney of some sort. 2 points to that. First, the habeas court clarified what the indictment says, and this court can see the indictment in the record. And what the court made a factual finding of is really what it's saying is this is the person who presented the information to the grand jury. The sheriff was not holding himself out to be a prosecutor, an assistant district attorney, or a lawyer in any way. Instead, he was the individual presenting these facts to the grand jury to make its finding, its determination of whether there's probable cause to continue. So that, in and of itself, renders this claim without merit. But I think even more importantly is, to the extent that even if it were true, there's no case law out there that says that renders the indictment invalid. Even if the sheriff were representing himself out to be an attorney and presenting this to the grand jury, that might be a problem for the sheriff, and he might indeed be in violation of the law that Mr. Ortiz cites. But that does not preclude the jury from making the grand jury from making a finding of probable cause.
Is the indictment signed by the District Attorney General?
The record will be more accurate by that, and I don't.
How did the trial court or the habeas, I'm sorry for cutting you off. How did he come to this determination that the sheriff was acting as the witness? I know it's custom.
I think it was a mixture of experience and the face of the indictment. That even though it says prosecutor, doesn't necessarily mean that he was being an attorney, and generally, customarily, that might be how they list the person who is presenting these charges. I don't know if it was signed by the district attorney. I don't recall if there's any case law that it has to be the grand jury, as long as it's signed by the foreman.
Well, I mean, the reason I ask that question is when you're talking about the jurisdiction, if there was a question as to who presented it, the grand jury still came back with a finding, and if it was signed off on by the district attorney general, without any case law to back me up one way or the other, that seems to potentially cure whatever issue there might be about jurisdiction.
And I don't think there would ever be an issue with jurisdiction. It might cure the potential issue with the sheriff.
No, right, but I'm just saying, if there was a jurisdictional issue, which would be a habeas issue,
Correct.
that would seem to cure the jurisdictional issue.
Certainly.
As the DA has signed off on the work of the grand jury, and he or she wants to proceed with that charge.
Yes, Your Honor. To the extent that there's any issue, that has been cured. But ultimately, this complaint does not invalidate the indictment or remove jurisdiction from the trial court. And that is what is necessary for habeas relief. Turning to the second issue, and I'll go still to this indictment. The petitioner also complains that the indictment didn't charge a violation of Section 524, 3913-524. And I think I might have, in my brief, slightly touched a little bit on a mistaken thing. I initially understood Mr. Ortiz to complain that he was not charged with a violation of Section 524. So Section 524, I believe it's Part A, has an independent crime for failing to comply with the requirements of being on this registry, of being on community supervision for life. Now I understand that's not the complaint. The complaint is that this sentencing enhancement of being on community supervision for life somehow violates Apprendi and constitutional law. Again, two points. First, that doesn't render the judgment invalid. It makes it potentially voidable, but it is not inherently void on its face. But more importantly, what Apprendi and its progeny mandate is that anything that is going to enhance the sentence, the facts have to be alleged in the indictment and have to be proven beyond a reasonable doubt to a jury. The fact that of this sentencing enhancement of community supervision for life is the underlying offense, which was included in the indictment. There are no additional facts or nothing else that the state has to include in the indictment that in any way would render the trial court without jurisdiction to either enter judgment or impose this sentence. The specific subsection of the sentencing enhancement does not have to be included in the indictment, and this court sees that all the time with drug-free school zones and range offenses and things of that nature. That doesn't have to be included in the indictment. Turning to the next issue, that is the last substantive issue of habeas relief, is that my understanding of the complaint now is that after the grand jury returned the indictment and jurisdiction went to the criminal court, that the complaint is the General Sessions Court improperly issued a capias and erroneously arrested Mr. Ortiz. I don't know whether that is factually correct. It might be in the record. If it is, it certainly could be a problem for that arrest. That does not render the criminal court to lack jurisdiction for the indictment that had been returned. If that happened, it's certainly unfortunate, but it does not divest the criminal court of the jurisdiction that it gained at the time the indictment was returned. And so once that indictment was returned, the court had jurisdiction and could impose the sentence. And we are looking at the sentence imposed now, not the potentially improper arrest or improper capias. So those are the three substantive issues. The petitioner complains about a recusal issue. He referenced an order of this court. I thought I had all of the suspense, and I've gone through everything all the notices from this court. I might have missed something that this court ordered us to respond to that. If so, I certainly apologize. I'll double check as soon as I'm done with this and respond. But ultimately, I don't recall the record including a motion to recuse, and the trial court was not required to sua sponte recuse itself. And I think to the two points that Mr. Ortiz makes about why the court should have. First, the delay of 241 days, I believe he said, we certainly wish trial courts could do a little bit better, but that is not a significant length of time by any standard.
If I understood in looking at the record, the briefs, wasn't it originally circulated to Division 9, Shelby County, which was closed at the time? It had lost its judge, and therefore it had to be recirculated, and that would be part of the reason for the delay.
The record is more accurate than my recollection, but I think that is the case. And so I think that explains some of the delay. But ultimately, the fact that this is several months of delay does not warrant sua sponte recusal by the trial court. And secondly, again, the trial court's order is in this record, and I certainly think, I can understand Mr. Ortiz's frustration with it, but I don't read it to have ever called him a liar or to have made credibility findings of his complaint. And in fact, that would have been improper for summary dismissal. You have to assume what he says is true and then and determine if that makes a colorable claim. It did make a finding of fact, but again, as we discussed with regards to whether the sheriff was the prosecutor, it never said that Mr. Ortiz was lying about this or that he was trying to mislead the court, at least as I can remember. What it meant was, I see why you think this. It puts him down with the word prosecutor. This makes perfect sense. Let me clarify that for you, and here's what it actually meant. So I can understand the frustration potentially, but ultimately neither of those complaints required sua sponte recusal by the habeas court. For all those reasons, we think that it was a proper summary dismissal and there was no need to recuse. And unless this court has questions, we ask that you affirm that summary dismissal. Thank you.
Thank you, Mr. Coleman. Mr. Ortiz, you still have 5 minutes remaining if you choose to use it.
Thank you, Your Honor. And hopefully I won't take up those 5 minutes so I could get out of your hair. I just wanted to address a couple of points that the general brought up. And one of the points that he mentioned early on was that there were only 2 instances in which habeas corpus applies. One is, obviously the most foundational one is that the judgment is void. And that, I think, to say that omitting a not less than substantial amount of time that you'll be serving on a sentence, like I said, in this case, Mr. Ortiz was, I think the base felony offense, he had 3 years probation, and after that he was done with that. Yet there is a lifetime parole that comes attached to that, and there was nothing on the indictment. If the notice guarantee under the U.S. Constitution, Tennessee Constitution, are to be interpreted the way the state wants, it would mean that we could just forget whatever we want and then later on justify by saying, well, it's not really that important, or it wasn't really that prejudicial, or it wasn't really that damaging to the defendant. But I think that when a person is a disabled veteran with diagnosed post proceedings, is diagnosed with post-traumatic stress disorder, and his reliance on counsel to do the things that he needed to do to defend Mr. Ortiz, it becomes clear that if the indictment, as stated in Hill, is missing an essential element, or as it is explained by the Tennessee Supreme Court in Anglin and Archer, that either the court was without jurisdiction, or were the proceedings so defective below, I believe that's one of the lines in Archer or Anglin, I can't remember which one, but if the proceedings are so defective below so as to call into question the validity of that judgment, that is the basis for a void judgment. Now, here, what I understand the state to say is that, well, the sheriff simply presented, but there is no reference, neither in the state's brief nor in his arguments today, to what law grants the sheriff the ability to do what he did and to seek what they, because otherwise, I believe that it could open the door to anybody that may not like somebody else say, well, I'm just simply going to go and present this, and we just simply presented it, and that's the end of it. And after that, there's no more review. There's nothing you can do. The proceedings in the grand jury are secret, so it's not like the defendant gets any access to what happened in those proceedings. And then to say that the person who secures that indictment can be it's not required to be the district attorney general as is prescribed by Tennessee law. I think that stretches the interpretation of the law beyond what the legislature intended. Therefore, Your Honor, and I know that I think Ms. Dyer asked about whether or not the indictment was signed by the district attorney, and just out of candor, on the second page it is signed by the district attorney. The question then becomes can the district attorney, by a stroke of the pen, validate the indictment in that way? Can an unauthorized actor secure an indictment by whether it's presenting it, or although they don't use the word presentment, but it comes very close to it. Presentment is defined by statute, and that is typically done by one of the grand jurors themselves. So I don't think that that's what the state may be referring to. I may be wrong, but I don't think that that jives with that definition. But neither can we assume, because a lot of the things that we're doing here are speculating. We're speculating, how did, I think Judge McMillan asked, how did the judge know these things about the sheriff and what his role was? We don't know. The answer is we don't know. And the record won't say. All we have is the words of the judge saying, this is customary, this is how we do things, your petition is without merit, but there is no legal analysis that bases that on Tennessee law or in any precedent that I have been able to find from this court saying that, this is how we do things. And even though the legislature said, no, you can't do this, we allow it in our courts. And I think that calls into question the proceedings as a whole, Your Honor. So with that, I'll yield the remainder of my time.
Mr. Ortiz, we appreciate your argument today. We have read your brief. It is extensive, and we will read the record as we come to a decision in this case. Again, we appreciate your argument, and we're going to take it under advisement, the matter under advisement. Just so you understand, our opinions are normally going to be issued within 30 to 60 days from today, hopefully, given you raised numerous issues in your brief. So we'll try to reach that deadline. But again, your brief is extensive. But we appreciate your argument here today.
And I appreciate your time and your candor and your warm welcome, Your Honors. Happy New Year's. And it was a pleasure being able to argue before the Court of Criminal Appeals. I just hope that you guys, I just ask as a last thing that you reverse and remand.
Thank you, sir.
Thank you.
Thank you, Mr. Coleman. I think that concludes our docket for the morning. We'll be in recess until 1:30.
All right.